In a watershed ruling that redefines the separation of powers for the 21st century, the Supreme Court of the United States has struck down President Donald Trump's sweeping reciprocal and national security tariffs, delivering a catastrophic blow to the administration's America First economic doctrine. On February 20, 2026, the court delivered a significant ruling in the consolidated cases of Learning Resources, Income vs. Trump, and VOS Selections, or United States. The decision, made by a 6-3 vote, clarified that the International Emergency Economic Powers Act, or IEPA, enacted in 1977, does not empower the president to unilaterally impose duties or tariffs. This ruling marks a pivotal moment in the interpretation of presidential powers regarding economic measures. In a significant ruling, Chief Justice John Roberts, joined by Justices Gorsuch, Barrett, Sotomayor, Kagan, and Jackson, clarified the limits of executive power under the International Emergency Economic Powers Act, or IEPA. The court emphasized that while IEPA permits the executive branch to regulate commerce during national emergencies, it does not grant a blank check to override Congress's exclusive authority to impose and collect taxes as outlined in Article 1 of the Constitution. This decision reinforces the balance of power between the branches of government. The global baseline tariffs, 10 to 20%, imposed in April 2025 on nearly all imports were declared unlawful. Punitive duties levied on China, Canada, and Mexico, justified by the administration as a countermeasure to fentanyl trafficking, were vacated. Crucially, the court did not invalidate tariffs imposed under Section 232, National Security, covering steel, aluminum, or Section 301, Unfair Trade Practices. However, legal experts warn these statutes now face heightened scrutiny under the court's revived major questions doctrine. The Treasury Department is sitting on approximately $160 billion in collected duties now deemed illegal, sparking a refund war as importers and foreign nations demand immediate repayment. In a furious response, President Trump denounced the ruling as a disgrace and immediately announced a Plan B. He invoked Section 122 of the Trade Act of 1974, which allows for temporary 150-day tariffs of up to 15% to address balance of payments deficits. While technically legal, this move is a stopgap measure that requires congressional approval to extend beyond 5 months, setting the stage for a brutal legislative showdown in the lead-up to the 2026 midterms. My analysis. The February 20th decision is not merely a trade dispute resolution. It is the most significant retraction of executive power since Youngstown Sheet and Tube Company versus Sawyer in 1952. For decades, the American presidency has operated as an elected monarchy in matters of foreign economic policy, using national emergency declarations as a skeleton key to bypass legislative gridlock. The Roberts Court has effectively snapped that key in the lock by recruiting Justices Gorsuch and Barrett, conservative jurists appointed by Trump himself. The court has signaled that the textualist interpretation of the law supersedes partisan loyalty. The unitary executive theory, long the darling of the conservative legal movement, has been cannibalized by its own creation, the originalist revolt against the administrative state. The irony is palpable. The administration's reliance on IEPA, a statute designed for sanctions against rogue states like Iran or North Korea, to rewire the entire global trading system was always a legal gamble. It was an act of hubris. The administration assumed that the judiciary would defer to national security claims indefinitely. They were wrong. The court has drawn a line in the sand. Taxation is not regulation. By stripping the White House of its IEPA war chest, the court has forced the executive branch back into the negotiation room with Congress, a body that has been atrophied and dysfunctional for 20 years. We are witnessing the forced reanimation of the legislative branch, not by its own will, but by judicial decree. The immediate ramifications are chaotic. The U.S. Treasury is now holding $160 billion in what is effectively stolen property. The legal battle over refunds will be the defining corporate litigation event of the decade. Small and medium-sized importers, SMEs, who bore the brunt of these cash flow crippling taxes will likely be last in line behind Fortune 500 giants with armies of litigators. Expect a secondary wave of bankruptcies among SMEs who cannot survive the liquidity crunch while waiting for federal reimbursement. The market now faces a paradoxical shock. The removal of tariffs is deflationary, but the uncertainty of Plan B, Section 122 tariffs, introduces extreme volatility. Supply chains, which hate uncertainty more than high costs, are freezing. Trump's pivot to Section 122 is a desperate tactical retreat. A 150-day timer is useless for strategic industrial planning. No factory moves from Shenzhen to Ohio based on a 5-month tariff window. This effectively kills the reshoring momentum the administration sought to build. The result is pure economic friction, high costs without the long-term structural benefits of protectionism. Global adversaries and allies alike smell blood. The Supreme Court has inadvertently advertised to the world that the U.S. president is not the sole proprietor of American economic power. For Canada and Mexico, this is total vindication. Their refusal to capitulate to the fentanyl tariffs paid off. They now possess a playbook for future disputes. Stall the White House and wait for the courts. The USMCA is strengthened, but U.S. leverage within it has evaporated. Beijing will view this as a symptom of American systemic paralysis. While Section 301 tariffs remain, the Liberation Day universal tariff was the real threat to the Chinese export machine. With that gone, China gains breathing room to stabilize its internal debt crisis. We are shifting from a hot trade war to a lawfare Cold War. The U.S. cannot use blunt force economic coercion as easily anymore. Future containment of China will require legislative consensus, something the U.S. political system is currently incapable of producing. This signals a potential plateau in American containment strategy, giving the global South and BRICS plus nations a window to accelerate their de-dollarization efforts while Washington fights itself. For the 2026 midterms, the trade chaos will become the central issue. Expect free trade Republicans to clash with MAGA mercantilists in a civil war for the party's soul, potentially costing the GOP the Senate. Emboldened by this victory, importers will now target Section 232 steel aluminum. Within 24 months, I predict the Supreme Court will narrow the definition of national security in trade statutes, effectively ending the era of protectionism by decree. With executive authority neutered, the U.S. will be forced to return to the 1990s style of massive omnibus trade legislation. However, given polarization, this likely means paralysis. The Supreme Court has asserted its dominance, but in doing so, it may have rendered the U.S. government too slow to react to modern economic warfare. By 2030, we may look back at this ruling as the moment the U.S. voluntarily disarmed itself in the geo-economic arena, sacrificing strategic agility on the altar of constitutional formalism. If you liked my analysis, don't forget to like, share, and subscribe.